Good afternoon. Thanks to each of you for joining us for today's colloquium. Dr. Keela McCarthy is Associate Professor of English and leads the writing program at Chestnut Hill College. She has taught both early American and British literature, foundations in the liberal arts, and writing, and has also been integral in the development of the delivery and development of the Welcome to CHC courses for new SUS students. Her scholarly interests include writing pedagogy, early American literature and Native American literature, and 18th century British literature, including multiple publications in early American and 18th century British literature. Dr. McCarthy holds a PhD and MA in English literature from the University of Maryland and a BA in English literature, honors in women's literature from the University of Miami. Her colloquium today, Searching for Native Voices in the Records and Remains, focuses in part on her sabbatical research from fall of 2021. And as I remarked to Keely as we were getting started, it was great to see this happen. It was one of the many unexpected outcomes of COVID that you had to make changes in your plans from your original sabbatical plan. So delighted you were able to do that and join everyone and looking forward to your presentation today, Keely.
Thank you. Thanks, Chris. Yeah, I felt very blessed to be able to change my plans, that they were flexible, that the college was flexible in letting me delay a year and to take a really much needed break. I felt extremely lucky. So this is my kind of what I did on my sabbatical talk. And so thanks for coming. I spent my sabbatical, Greg, if you could, where is the slide thingy? Is this, I can go, okay. I spent my sabbatical studying some of the oldest colonial records in the US. The records in the Northampton County, Virginia courthouse on the southern tip of the eastern shore of Virginia, the peninsula between the Chesapeake Bay and the Atlantic, are the oldest continuous written records in the country. As an early Americanist, I've wanted to snoop around in these records for a long time. Besides the historical and cultural interest, this county is where my mother and all of her family are from, going back as far as these records go. In addition, my grandmother worked in the courthouse among these records for over 2 decades. And I wish that I had had the opportunity to do this research when she was alive, because she would have loved to discuss this and to assist. This is a newer version of the courthouse, but not the newest. The newest looks like a modern courthouse, but this is the 18th century version and 18th and 19th century version and the little kind of offices and town hall. There are many interesting things about the early court records. Insights into the formation of a society and a colonial government, fragments that reveal the development of the institution of slavery, intercultural and neighbor relations, references to the Anglo-Dutch War, the county's response to the English Civil War, and the first recorded divorce on the shore, public policy on the smallpox epidemic, and much more. I utilized these records for this project in spite of a recent call to early Americanists published simultaneously in Early American Literature and William and Mary Quarterly, the 2 journals in the field, to expand our source material in order to diversify the people and narratives that we study and to enrich the perspectives that we have access to. The editors make the point that early American studies has simply not done enough to include non-Europeans as our primary subjects of study. And by looking almost exclusively at official records, when we study Native Americans or the very earliest Africans in America at all, in early American studies, we're working through the voices of colonizers like my ancestors. What could be more bureaucratic, official, and Western than court records, though? These records, though, are extraordinary. The records in the Northampton County Courthouse go back to the 1620s, continuous from 1632. They're continuous because during the Civil War, Richmond said to everybody in Virginia, "Send all of your records. They're coming for us." And Northampton, which is a very contrary place, they were like, "No, we're not going to do that." And then Richmond burned down. So there were records that were lost, but these are the only continuous ones that are that old. And when we're talking about colonial times, where else can we look? This is one of the challenges that researchers have faced. We're not trained as archaeologists or cultural anthropologists. Whether historians, literary scholars, or art historians, early Americanists work with visual and written texts. In studying the early contact period of the Eastern Shore, the challenge is also that there are no obvious places to go, no museum, reservation, or university with tribal records or remains. The editors writing in early American literature and William and Mary Quarterly suggest that we get creative, examine artifacts, oral history, fragments of evidence that might provide an alternative story, another voice, a different context. And there is a growing subfield of material culture within early American studies. Reading this call for expansion and inclusion shifted my work, but I did first search the courthouse with an intuition drawn from my earlier scholarship on early American natives, that even working within colonial records, if we ask different questions and read in the margins, we can access an alternative narrative. While the capital, James City, as it was in the 17th century, and the area around what is now Hampton Roads, starved, explored, settled, fought with neighbors, changed governors frequently, bought and trapped people from another continent, built a lawmaking body, and much more, colonial settlers were doing most of these same things on the other side of the Chesapeake Bay in one of the original 8 counties in the Virginia colony, which was later divided into 2, Northampton, the southernmost, and Accomack, just north of it. This area, still referred to as the Eastern Shore of Virginia, Maryland, and later Delaware, now called as a whole the Delmarva Peninsula, was explored by John Smith in 1608 and had English settlers living there permanently in the 1620s. A young man named Thomas Savage was sent to live first with Powhatan on the western shore, where he learned the language of that people, and then to the lower southern eastern shore, where he served as interpreter to the Accomacs and Oconomowocs, who both had dialects similar to Powhatan's. What happened next is maybe folklore, maybe history. No record remains of the earliest events. There were a number of related and distinct native groups on the lower shore. The English settlers referred to the leader of one of these groups as the Paramount King and called him the Laughing King. Also named Esme Shahanans, the king is described by the English as easygoing, friendly, and generous. Giving first Thomas Savage, then Sir George Yardley, and then others, so much land that by 1633 he had gifted it all away, though his chiefs still held land themselves. As many have explained of other Native American groups, property was not a native concept, and what giving it away meant to the Laughing King is not clear today. Helen Roundtree and Thomas Davidson, who have the most in-depth study of the Eastern Shore native life to date, describe Eastern Shore natives moving around their territory, fishing in marshes, hunting and growing crops, and building fixed but not permanent shelters. When the English settled on the shore, they built homes that looked much like the native shelters. They grew crops, fished, and hunted. If their settlements did not look distinct from native settlements, possibly the Laughing King saw guest neighbors instead of a future colony. Whatever he meant by his offers of land, which was surveyed and then made official with royal patents, the English took the gesture to indicate ownership. Later generations of the descendants of English settlers read this history of giving as a legacy, which they were the inheritors of generosity, friendliness, native Southern hospitality. Historians of the Lower Eastern Shore praise the peaceful actions of the 17th century Native Americans on the shore and credit it with possibly preventing armed conflict and saving Native life and culture for a time. Thus, the portrait that we have of the natives of the time of colonization, represented in history books, a few local commemorative plaques, and local lore, is of peaceful and generous natives who eventually died out or married with the African population in later generations. I started digging around in the court records in May of 2021 when the courthouse opened back up. Not sure what I was looking for or even which century I wanted to work in. My expertise was in the 18th century. I had prior scholarship on one of the few published Native Americans in the 18th century, but I originally had an idea to work on something related to enslaved people challenging their status in court, which there is at least one record of in Northampton. I knew this ahead of time because my grandmother had described it to me, and after her death, I found a paper on which she had transcribed that record. It mirrors a scene in Elido Equiano's narrative from the 18th century, and I had an idea for an article on those two documents. But when I came back to Philadelphia and examined my research, I saw that I had gravitated instead to the earliest records and that there were so many instances of Native Americans at court. I just have to say that the people at the courthouse were so kind to just let me, muck around in records. Librarians and archivists do not usually let you do that. And this was like a totally how not to proceed with a research project, right? Like I just sort of went there and started reading stuff and then followed little paths and leads. Anyway, indeed, almost every court day in the middle of the 17th century had records from Native peoples, which meant that they were there at court, mingling, exchanging. It presented a very different picture of the shore than the one I knew. And the gap between that historical image and the shore today was intriguing. The records also reveal a gap between the legend of the generous Laughing King and the complex diplomacy that they actually engaged in, of generosity, strategy, and protest too. Finally, there are limits to what I could see in these records, and the project also answers the call, I hope, to move beyond colonial documents. So the English arrived, got some land, immediately set up their institutions, and named the Lower Eastern Shore as one of their counties. What about their neighbors? The legal status of the Eastern Shore Native Americans, or what would be considered their legal status within a colonial system, is unrecorded. The Virginia Company did not create a general policy to guide the English settlers' actions towards the tribes near them, but early on, several different relationships developed. There were individual families, small groups that were independent. There were also independent political entities, and there were tributary tribes. These had been defeated and had signed treaties to surrender and in return become English subjects. So what would it mean for an Indian to be an English subject in 17th century Virginia? It's not entirely clear because the topic of their legal standing was not mentioned by the General Assembly of Virginia until the 18th century, when the Assembly passed restrictions on their rights. For example, in 1705, the General Assembly ruled that, quote, no Negroes, mulattoes, or Indians bear any office, ecclesiastical, civil, or military, or be in any place of public trust or power in Virginia. Similarly, in 1723, the voting rights of Indians and Negroes were limited, though they had not previously been officially acknowledged. For the most part, the natives of the Eastern Shore did not fit neatly into any of these three categories. The difference in the relationships on the Eastern Shore might first have to do with the small population early on of both natives and colonists. By the time the English settled on the Eastern Shore, the number of Native Americans was greatly reduced from diseases contracted from early Spanish explorers. Contact with the first English settlers and the diseases that they brought killed more. Despite this reduced population, there were still many tribes represented on the shore. During his exploration in 1608, John Smith identified 8 distinct Indian settlements, but others are named later in records and on maps. No Eastern Shore tribe was listed as one of the official tributary tribes of the Virginia colony in 1670, which makes sense because there had not been any large-scale battles to institute that subordinate status. But Roundtree and Davidson argue that though no Eastern Shore native was involved in Bacon's rebellion on the Western Shore, and none signed the 1676 treaty after that conflict, they were treated by the colony as if they were signers. Roundtree and Davidson say that this allowed them the rights of citizens for a short time, quote, armed with their equal to English civil rights, at least until the late 17th century, they went to court on an equal basis with their English neighbors. Roundtree and Davidson based this claim about civil rights on the fact that Native Americans frequently appear in the court records in similar ways to the English settlers. But going to court and being treated equally in court are not the same, as we will see. And Native Americans used Northampton County, the court, frequently, much earlier than 1676. County courts in colonial Virginia were centers. This is an old picture of the courthouse you see a lot in Northampton County, but it's of the rebuilding of it. And this is a London picture, because we have no pictures of inside the court from this time. They were cultural centers and seats of power. Though for a while held in diverse places, they were where people met, socialized, made decisions, and voted. I found no descriptions of Northampton County court days, though we can imagine with all of these different people present together, the space of the court was a site of cultural exchange, where impressions were formed, language and objects maybe were exchanged, and all of this could have had a deep impact that is now untraceable. Drinking at court was allowed, but was periodically discussed as a questionable practice. Just to give you a sense of all the many things that were happening at once inside the courtroom. The court played many roles. County courts recorded wills, deeds, and orders, settled disputes, recorded directives from the governor, and the court's duties expanded throughout the century. In 1616, the reorganization of the Virginia Company created more local control, which was held by the courts. A county court was formally established on the Eastern Shore of Virginia in 1625, when the governor and council charged the commander to decide any small cause to save the trouble of traveling to the capital, James City, for court. The court was given more authority in 1632 when ordered to meet monthly. To summarize a long history of changes in the power of the colonial courts, mostly out of the convenience of decisions being made locally, the county courts in the Virginia colony were given more and more power throughout the 17th century. This led to a sense of independence on the shore, which was separated almost like an island from the mainland. This led actually to them trying to break away in 1656, which was a whole other thing I thought I would write about, but decided not to. Another story. The court also became more central to colonial life as the English population of the Virginia colony grew on the Eastern Shore 250% from 1632 to 1655. This growth in the number of people coming to court led to an increase in the number of commissioners and justices, as well as an increase in the number of days the court sat in session. And even when the court wasn't in session, the 8 justices of the peace were deputized to, quote, act and do all such things as by the laws of England. That is to say that they heard and decided felony and petty offense cases. When it came to the governing relationships with the Native American populations, in the absence of a formal treaty or specific guiding rule of law, a lot was left in the hands of court officials. This made London nervous. for a county to conduct what were seen as international affairs. For example, in 1651, the court ordered, quote, a Dutchman, unnamed, to make restitution to an unnamed Eastern Shore Native American. The prior year, the court ruled, quote, that Mr. Toby Norton shall forthwith deliver unto King Tom the gunpowder and horn, shot, and shot bag which he took away from him, as well as the weeding hoe that Norton stole. In 1652, the court ordered William Andrews to, quote, send to the Queen Potamote 100 arms length of Roanoke tobacco, to the King Potaman 10 wooden shoes, to the 2 Indians, each a coat, to the Indian shot by the wife of Toby Selby, 20 arms length of Roanoke, whereupon a valuable satisfaction is to be made. London officials wanted all agreements, even minor ones, between their colonies and Native American tribes to be approved by the king. With no access to the King of England and not always happy with the county court, the Eastern Shore natives occasionally took their case to someone who might have been perceived as having higher authority, the governor, though in these cases, the governor would hand the case back to the county court. In 1667, for example, the court recorded the order from Governor William Berkeley for the court to investigate a complaint and report back to the governor. Maybe the natives on the shore observed their English neighbors going to the governor for advice, as in 1651 when they went to him to request advice as they sorted out rumors of Indian attacks. There were no attacks that year, or any year, except for 1644, and the colonists' precautions against these anticipated attacks seem to have led them to strike first. At other times, Eastern Shore natives interacted with the court like insiders, being called on to testify both against and in defense of colonists, filing their own wills, and in one instance, recording a line of succession. Going to court to file a will suggests that Native Americans on the Eastern Shore understood the court's role in colonial society, the power it had as keeper of records and enforcer of what is recorded at court. Though we have no way of knowing whether these were his words, unlike the third-person reports of most other court records, the June 1656 last will and testament of Wakawamp, emperor, is in the first person. The will is signed by 3 English witnesses and by Wakawamp with a mark. In addition, the next court records entered in 1657 contain witness testimonies of the recording and signing of the will. One testimony reads, quote, the deposition of Captain George Parker taken in open court saith that he did write the last will and testament of Wakawamp, great emperor of the Eastern Shore, and that your deposed, to the best of his judgment and knowledge, did make the said will according to the construction of the interpreter. This sort of testimony is unusual in the court records of wills and reveals to us that this particular record was seen as important and perhaps also shows concern that the will would be contested. While parts of the court records are torn, of that particular court record, unfortunately, are torn, the remainder states that the emperor leaves his guns, his house, and his position to his daughter. Quote, I desire that none shall rule but my only daughter. He gives instructions for what would happen if he died when she was not yet of age. Was the emperor concerned that other Indians would contest his will, that the English would? Was he concerned that his daughter's right to the house would be challenged, maybe during this transition of power? We don't know. However, the tribe is the same that came to court in 1651 to complain about English incursions on their land. And one of the witnesses in the signing of the will, Randall Revel, was one of the defendants in the case 2 years earlier against colonists who were encroaching on their land. This tribe was in and out of court petitioning for their land rights and making wills from at least 1651 to 57. Sometime between 1654 and 56, the emperor seems to have relented and sold land to the colonists. Referring to this prior land sale to the English, in his will he says, quote, out of love and affection I always did bear to the English. And he asks that the English would continue to allow the king's people to occupy the land and requests that Wakawamps heirs, if they wished to move north to Wachapreague, the English would, quote, procure a patent for that land. By filing his will in court and making this request for future protection, the king makes the English, the court, and by extension, all of the area colonists executors of his will. The court played this role for colonists and now for this Native American emperor as well. Another way that the Native Americans and colonists on the Eastern Shore used the court in similar ways, this is actually, you can't read this anyway, it's this crazy longhand, or maybe you can, maybe Barbara can. This is actually not relevant to any of the records I'm quoting. I just wanted you to see a picture of one of the records. I couldn't find the, it's crazy, they let me photocopy everything. And I was like, no, really? But I did. It's pretty amazing. Anyway, I couldn't find my photocopy of the will. Another way that Native Americans and colonists on the Eastern Shore used the court in similar ways is in bringing cases of libel or threats. The Northampton Court records records from the 17th century are full of cases like this, mostly colonist against colonist. Some are one-time events, others records that allow us to piece together fuller stories of disputes between married couples, servants and masters, enslaved peoples and masters, and between neighbors. And I got very lost some days tracing soap opera-like stories where people dragged each other into court back and forth. And then I was like, what am I doing? Okay. In 1654, Adaman and other Indians charged Rich Kellam with threats against him, alleging that Kellam, quote, said that if he had the Indian at the door, he would cut his throat, end quote. For this, quote, impudence and affront, the court imprisoned Kellam until the next court session, which would have been a month, at which time he would also be fined. What meaning can we make, though, of these glimpses of Native American appearances in court? The records contain no commentary. Were they stared at when they arrived at court? Was their presence so common that there was no commotion? How did they represent themselves? Who was their interpreter? Did they need an interpreter? Could they read what was recorded? How were they addressed by court officials? We don't know the answers to any of these questions. But their use of the court leaves us clues about how they understood their use of the court, and also clues about the legal rights of Native people on the Eastern Shore. From their own use of the court, we know that, at least in practice, 17th century Native Americans on Virginia's Eastern Shore had the right to defend themselves in court, the right to sue for damages in court, and the right to property that could be passed down. We also know from these same records that there are large gaps between law and practice. For example, a 1659 Virginia law allowed natives in the colony to carry arms within their own limits. However, on the Eastern Shore and elsewhere, those hunting grounds had been severely cut back. And while a 1662 statute ruled that Indians could not be slaves and could not serve as servants for longer than the length of time an English servant could serve, there were essentially enslaved Indians on the Eastern Shore, which we know because they were occasionally listed as property in wills. In 1676, Bacon's Rebellion resulted in a law that allowed slavery for life for Indians. Even though the provisions set up by the rebellion were repealed when the leader, Bacon, died, those allowing Indian enslavement were reenacted. In 1808, the Supreme Court of Virginia ruled that a 1691 law for free and open trade between colonists and Indians meant that no Indian or their descendants in Virginia could be enslaved for the reason that slaves could not trade. So while there were few colonial laws legislating the status of Native Americans on the Eastern Shore, and the laws that existed were often undermined, Native Americans themselves had early on figured out how to use the court, the only political instrument on the shore to attempt to protect what they had left. This doubleness of the court protecting both native tribes on the shore and pushing the agenda of the colonists is seen most starkly in the numerous records of land deals. Most Native Americans could not sell land. Only their leaders could sell land. Other than that rule, which was created by the English, little about these transactions is known. Were the sales coerced? If not, were they agreed upon by the whole tribe, or was there controversy about them? One thing is clear, though, from the records. Eastern Shore Native Americans knew what it meant, short and long term, to sell their land, and it was distressing for them. These are just 3 quotes of these types of land sales, but there are many like this. While we don't know if the words written down are the same used by the Native Americans, and if not, what was lost in translation, that is unlikely, since the sales follow a rhetorical legal pattern, sounding like they were written from 17th century colonial-style LegalZoom. Why record them at the courthouse at all? It benefited the colonists, who maybe insisted on it so that the sales could not be contested later. It would have been of no benefit to the Native Americans, except in the rare cases that they added specific provisions, the most common being that they could still live on part of the land. Making use of the courts, even to represent grievances in the end, was of limited benefit to the natives of the Eastern Shore. Transparency does not equal justice, as is clear in the 1662 record of the agreement made in open court in front of witnesses and with the use of an interpreter between Nathaniel Bradford and the King of Machipungo. In exchange for, quote, a suit of clothes and other things, Bradford received 200 acres of land and the use of the king's house, which would revert to Bradford's heirs. It could be that the colonists on the Eastern Shore were motivated to make these sales transparent because of this directive from their governor. Gentlemen, having been frequently informed by the testimony of diverse and undoubted credit that the Indians commonly called by the name of the Laughing King's Indians have been ever most faithful to the English, and particularly that neither they nor their king in the last bloody massacre could be induced to engage with our enemies against us, and so by consequence kept the remoter Indians at least neutral in a time of general commotion against us, had been, if not ruinous, at least of an insupportable prejudice to us in that conjunction. And considering that we cannot reasonably hope for the like efforts of their friendship in case we should need it again, which God knows how soon it may be, unless we abstain from acts of rapine and violence, which they say we begin to do by taking away their land from them by pretenses of the sale of a part. My desire, therefore, to you is, and I make it in the name of peace and safety of the country, that you suffer no land to be taken from them, but what shall be allowed both in justice and convenience by the full court, and in case the commission disagree in their opinions, that you refer the whole matter to be considered by a full court at James City. Your humble servant, William Berkeley, 1651. The beginning of the governor's letter suggests that there was more land lost than what is recorded in these court records. His language also suggests that some or all of these are not mutually agreed upon. Calling the taking away of their land an act of violence, the Native Americans on the shore, through Governor Berkeley, have protested and also sent a warning. Northampton County's response was to record the land transfers in court, but not to stop them. Another record from this one from the next year articulates what these sales mean to Native American communities. Quote, whereas diverse Indians from the town of Occohannock have declared unto us that through the affectionate love they have borne unto our nation, have from time to time suffered us to sent upon their land for some small satisfaction received of us for the said lands, insomuch that the said Indians are now strayed from their hunting, a great past of their relief consisting thereupon. And also they have declared that lately diverse of our people have been in their woods and have laid out lands, even unto the very town of Anancock, which, if they should part with, they should utterly destroy the inheritance of themselves and their prosperities. It is therefore thought fit and ordered that no man shall presume to seat upon any land of the north side of Punkatees until compensation be made with the court by some Indians, that the same be manifested to the court by some Indians, being of their great men. Though mediated through the official language of the county clerk, Edmund Matthews, summarizing both the appeal and the ruling here, this passage gives us a glimpse of the argument that the natives near Punkatees Creek made in court that day. The fact that it is translated or transcribed or dictated by the colonial officials means that they, the colonial officials, had to articulate these concerns. All parties present that day seem to already recognize that if the tribe gives up their land claims, the tribe will cease to exist. Quote, they should utterly destroy the inheritance of themselves and their prosperities. This suggests that this was a familiar argument. It didn't need explanation in the records. While later generations of Americans would describe this colonial history as a slow, inevitable disappearance of the Indians, at this moment in 1652, the long view was fully recognized by everybody in the courtroom. Yet despite this insight and powerful argument for protection, the court's ruling leaves open the possibility of further negotiation and purchase of Indian land, though orders that it must be done through the court. And this is ultimately what happened. That particular area continued to be contested in court. And in 1654, English settlers in that area were again ordered by the court to either get off the land or, quote, give the Indians satisfaction for the land. Sometime between then and 1656, the land was sold. The narrative of the inevitable disappearance of the native peoples was also already embedded in the rhetoric of the logic of the colonial system here in the 1650s. By 1656, Virginia's General Assembly had received so many complaints from Native Americans across the entire Virginia colony of land grabbing by colonists that the Assembly passed a law that said that land purchases had to be made in court, not in formal arrangements. In 1658, the Assembly made purchase of native land possible only with the permission of the governor or Assembly or local authorities who would have been also the court officials. So the Native Americans knew what was happening, and the colonists knew what was happening. The Native Americans may be wanting both to adapt to this new world and also to hold on to land and culture, the colonists wanting land to expand and settle roots, but also at least some of them feeling somewhat protective of their native neighbors from time to time. The Assembly saw the primary cause of tension between native peoples and colonists as the encroachment of white people on native land. They sought to stop this in order to alleviate tension. Enter the first reservation in the Mid-Atlantic. As these lands were being sold, taken, whatever was really happening, in 1641, much to his heir's horror, Thomas Savage gave hundreds of acres to the group of the Accomack Indians for the Ginkasking Reservation, named after a tribe that by the mid-17th century was referred to by that name. This became the General Assembly's answer to the rising tension. In 1660, the General Assembly intervened by allotting land to the Accomacs. The Assembly required that the land be surveyed by people from the mainland to try to alleviate corruption by English neighbors of the Accomacs. This land could not be sold, and 2 years later, the General Assembly used similar measures on the mainland to protect lands, very limited compared to what had been lost for other tribes in the colony. Back on the shore, by the end of the 17th century and on until the 19th century, most Native Americans were now living on reserved land. Then in 1813, the Ginkasking Reservation was closed as a fearful reaction following Nat Turner's rebellion, which occurred far from Northampton County, but reverberated throughout the South. Whites on the shore, who had previously had a mostly paternalistic attitude towards the natives on the reservation, became fearful that enslaved people would escape to the reservation, hide there, and foment a rebellion, it being legal for Native Americans to own firearms for hunting purposes. They shut it down, divided up the land into lots, and gave those lots to prominent tribal members. So where did they go? I grew up hearing the names and roads and towns on the Eastern Shore: Kiptopeke, Machipungo, Nassawadox, Anancock, but I had no stories that matched this history that I'm sharing with you today. No tribes are fully recognized legally on the Eastern Shore of Virginia, but digging Maryland recognized the Akahonik in 2017, which was a controversial move in Native American communities because the tribe had remained hidden in plain sight, and in assimilating all those years had not struggled and faced challenges that other tribes had. No tribes in Delaware or Maryland are federally recognized at all, and no Virginia federally recognized tribes ever lived on the Eastern Shore. The Chesapeake Bay Foundation has recently started to work on this history with a focus on how Native peoples used the waterways, and there are small acknowledgments sprinkled at state parks, like this sign at Kiptopeke State Park. On a research trip, I was updating my mother about this project. I was there to research the court archives, but I had more on my mind how to respond to the challenges to go beyond colonial records, back to that article in Early American Lead in William and Mary Quarterly. I was also telling my mother that what I had learned about the Ginkasking Reservation and surprised her with this. She had not known about it either. We pondered where to look for more. There are probably documents and objects all over these old homes, we both noted. Then my mother pointed to two objects, like right behind her, that I had always grown up looking at, a basket and a bowl. My grandmother, she said, always told me that she bought these from an Eastern Shore Indian woman. My great-grandmother grew up on a famous estate, Airville, and as an adult lived near Eastville, where there is a public park called Indiantown Recreation Park. Though it is now extremely obvious, I never knew until I was doing this research that this was the site of the reservation or part of it. Now Indiantown Park has a disc golf course and good bird watching sites and a playground. There is currently an active lawsuit to reclaim part of the land for the descendants of the tribe. People today who identify as Accomack Indians use as their tagline on Facebook, "the friendliest Indians of America," embracing that characteristic of the Laughing King. The history of this reservation is today not widely known, even by lifelong residents. And you can see some things are misidentified on this map, but there's the park on the seaside, on the Atlantic side, and the courthouse would be almost directly across from it on the other side of the yellow line in Eastville. And the only public acknowledgement of it is a historical marker near the courthouse and a 2013 sign at the Indiantown Recreation Park, which notes that 1813 was, quote, the first termination of reservation lands and detribalization of its owners in US history. Otherwise, there's nothing but the generic Indiantown name to suggest that there was a reservation, and before that, a free and open community of Native Americans whose homes used to be much of what became Northampton County, including the site of the courthouse. Thanks. That's Kiptopeke State Park. just some pretty pictures from the shore. Any questions or things you want to talk about? I'll say that this was an easy talk to write, but I'm really struggling to turn this into the article that I'm submitting to William and Mary Quarterly, which is a very traditional journal. They would like none of the story part and the family history, which is certainly new to me to write. I wrote a version of this that was totally different, and out of that wrote a draft of the article. But the article is becoming much less interesting without the apparatus of the search and the family history. So it sort of keeps changing in focus as I navigate that.